The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're now 9 months into the pandemic, and as we are all too familiar with, people have come up with a panoply of activities to keep them occupied while staying at home. Many have begun new hobbies like baking or birdwatching. Others have unfortunately dabbled in new vices like substance abuse or listening to podcasts. Meanwhile, quite a few have been catching up on classic TV shows, which, depending on your perspective, could count as a hobby or a vice. For example, I've heard from several people that have watched or even rewatched The Wire, David Simon's HBO series from the mid-aughts about cops, gangsters, and just about everyone else in Baltimore. But watching it now does show that it's, as you'd expect, dated in some ways. You can't help but notice that one thing McNulty's band of misfits could have used in addition to a measly wire was a drone. Then they could potentially track the movements of everyone in Baltimore. That's something the Barksdale clan could never have outsmarted. And neither could thousands of innocent people, which is why we have a Fourth Amendment. The Fourth Circuit reviewed a challenge to a real-life program that does just about that last week. We'll be looking at that case in a moment. Another, you might say different series from The Wire is All Creatures Great and Small, the BBC period piece adapted from James Herriot's novels about veterinarians in Yorkshire. Originally produced in the 1970s and 80s, a remake has actually just appeared this fall. Much of the action, if that word qualifies in describing what happens in the show, revolves around dairy cows. Well, they had some dairy cow drama of their own last week at the Washington State Supreme Court. The court addressed whether the state constitution's Privileges or Immunities Clause, a phrase that might be familiar to some listeners, in conjunction with the state's wage and hour laws, protects the privileges of dairy workers in providing the immunities of overtime. I have no idea if wage or hour laws of veterinarian practices came up on All Creatures Great and Small, but I'm sure it would have made for a thrilling episode, just like this case. We'll be talking about that decision today. Joining me this week are two IJ senior attorneys, Dan Albin and Wesley Hoddett, both very familiar with pandemic hobbies and vices. Let's first turn to Dan, who is going to present the Fourth Circuit case. Dan, is The Wire the greatest show ever made?
Well, it's certainly among them. And The Wire actually is a great setup for this case because it involves surveillance in Baltimore, electronic surveillance. But in this case, as you mentioned, it's about drone surveillance flying over the city, photographing up to 90% of the city for 12 hours at a time every single day. And so not only would the Barksdale clan and various criminals who are outside be photographed by these drones, but so would hundreds of thousands of Baltimore residents who aren't committing any crime but are still being surveilled. The case is Leaders of a Beautiful Struggle versus Baltimore Police Department. And the majority, written by Judge Wilkinson, finds that this surveillance program, which is the Aerial Investigative Research Program, is constitutional, does not violate the Fourth Amendment. And Judge Wilkinson describes in great detail how this program works and discusses the Fourth Amendment cases, especially Carpenter versus United States, which was decided a couple of years ago by the U.S. Supreme Court. And it's important, I think, to understand just a little bit about Carpenter because both the majority opinion and the dissent focus on Carpenter. So Carpenter was a case that involved the use of surveillance by cell site location info. That is not GPS info, but info gathered when your cell phone pings a cell location site. And in that case, the Supreme Court ruled that it did violate the Fourth Amendment to, without a warrant, obtain this cell site location info that enabled law enforcement to track the location of a suspect. I think in that case it was something like 84 times a day, as the cell phone was either used or pinged a new cell site, because it enabled law enforcement to, with quite a bit of details, very similar to GPS, track the exact location of the suspect each time the cell phone pinged the cell towers. And you can imagine if a cell phone is doing that, 80 to 100 times a day, you could get a pretty good idea of where someone has been each day. And if part of the investigation is, were they at the scene of a crime, or were they, at a location with other people that are suspects in the crime, it could lead to very valuable evidence for the police. But it can also lead to terrible civil liberties violations, because if everyone's cell phone data is available to the government like this, everyone's location could be tracked. And so the Supreme Court rejected the attempt to use this cell site location data in Carpenter. But Judge Wilkinson thinks that this surveillance program, this drone surveillance program over Baltimore, is not similar enough to Carpenter to violate the Fourth Amendment. And he points to a handful of key aspects of the program that he thinks differentiate the program from using cell site location info. So he points out that these drones are only up for 12 hours a day, weather permitting. They're only taking the photos during daylight hours, not at night. He points out that it only enables outdoor surveillance, unlike cell phone location info. Obviously, in most buildings, your cell phone is still in contact with a cell tower and can still report its location data. They're just using regular cameras, maybe high definition, but regular cameras to conduct this aerial surveillance, and so they don't see inside of buildings. Once somebody goes inside a building, you can't track them anymore. And then another critical fact is that the resolution for people is reduced to a single pixel. And this isn't based on the capability of the cameras. They're apparently able to do far more than that. But based on concerns raised by community groups and other people involved in instituting this program, the agreement that was reached was the resolution for a single person will be reduced to this pixel, and thus nobody can be identified by this one pixel. It's not even what color clothes you're wearing is supposed to not matter. They're supposedly unable to identify people by race or gender. They can just see that there is a pixel going into a building or walking down the street. And so Judge Wilkinson says, look, that's not enough to raise the sort of Fourth Amendment concerns that were at issue in Carpenter. And basically says this is something that is far more limited. It doesn't even have the same capabilities as street level surveillance cameras, which often use facial identification technology, can see far more about what someone's doing, have much closer on the ground resolution. But of course, street level cameras, are only generally going to be capturing the area outside of a business or a single intersection or a single part of a street, not the entire city like this drone aerial surveillance program does. At the end of the day, he says, look, it's possible that these could violate the Fourth Amendment if they operate in a certain way, but he writes, the basic problem with plaintiff's argument is that people do not have a right to avoid being seen in public places. And so he says, look, because all you can do is identify that there are pixels moving in and out of buildings, and you would have to use other surveillance technology to figure out who those pixels are and what's going on. The program, kind of viewed in isolation, is free from these Fourth Amendment concerns. And then towards the end of the opinion, he sort of adopts an ends justifies the means argument that actually reminded me a lot of Dirty Harry. For those who are not familiar, haven't spent their pandemic isolation watching Dirty Harry movies, Dirty Harry is this sort of extremely aggressive cop, some would say a fascist cop, who does not care all that much about the civil rights and civil liberties of suspects that he's going after, and frequently fails to get a warrant or do other things. But we, the audience, are supposed to be okay with it because we know that the bad guy is really the bad guy, and at the end of the day, everything comes out okay. And so in Dirty Harry, at one point, the district attorney is telling Dirty Harry why he's got to let this serial killer go, and says, we all of the evidence that you got was obtained illegally. Every single thing you did was illegal. And Dirty Harry says, well, what about the rights of the victims? What about the rights of the lady he killed? And Judge Wilkinson sort of mirrors that at the end of the opinion, talking about the rights of folks who are murdered on the streets of Baltimore, who are robbed on the streets of Baltimore, and points out, all of those people have their rights denied without due process, and that justifies why we have this program. Now, that's not normally how constitutional rights are supposed to work. It's true that the surveillance program is allegedly designed to help prevent murders and other crimes on the streets of Baltimore, but the rights of people who are being surveilled, like the plaintiffs in this case, who are community activists and organizers, and hundreds of thousands of people in Baltimore who are not committing any crime but still being surveilled, have to be taken into account. And the ends justify the means is not normally how we conduct constitutional jurisprudence. Nonetheless, that's how Judge Wilkinson ends his opinion. Now, there's a dissent in this case that I think is more persuasive by Chief Judge Gregory that sort of pushes back on a lot of the facts that Judge Wilkinson relies on, and points out that, sure, if you view all of this in isolation, and if this was the only technology or methods that the police had at their disposal, it would be pretty difficult for them to figure out who people are. But merely by having a phone book or a directory or something that shows the houses that people live in, you would be able to generally trace just about everybody because most people spend the night at their house. And so in the morning, when it's daylight, you can track them as they leave their house and follow them about wherever they go during the day and have a pretty good idea of what they're up to, because even if you can't track every single pixel all the time, you can still follow them to certain locations, and then you can cross-merge that with the surveillance camera data, other information that you might have about someone's location. And when you view all of these things holistically, it is a massive surveillance program that can, in fact, individually identify all of these people who are being surveilled without a warrant and tracked at a level that the Carpenter Court said it wasn't comfortable with, said that violated people's rights, because every aspect of their behavior was being tracked for days at a time. And in this case, the surveillance program stores, I think it was 45 days worth of data. And so you could easily identify and track someone for a month and a half using a combination of this aerial surveillance plus street level surveillance cameras, the license plate tracking cameras, all kinds of other surveillance things that are available to police, without even getting a warrant, without ever having any basis for suspicion. And lots of people could be tracked this way, and that's of great concern to Chief Judge Gregory. And so it's an interesting sort of tug of war. I suspect that this case will be headed to the Supreme Court very soon to address, how does Carpenter apply to this aerial drone surveillance program, and should we look at it in isolation and not imagine how you could combine the aerial surveillance information with other capabilities that the police have, or is that view, as the dissent puts it, putting one's head in the sand about the program's capabilities? And you should really be more skeptical of first of all, the government's claims about the limits that it puts on the technology, even though it maybe could go further than that, and that it also is too reductive in only focusing on the capabilities of these drones and not all of the capabilities that police have once they have access to that drone surveillance information. And so, Judge Gregory says, look, it doesn't matter if you're getting the information from these cell site location info from cell phones, or if you're getting it from drones flying overhead for 12 hours a day. You're still getting information about people's past movements for up to 45 days at a time. And that in and of itself is what reveals the intimate details about people's lives and violates the Fourth Amendment.
Well, how long do you think it is until this technology is used as evidence in a particular criminal case? And would that perhaps be a better illustration of its Fourth Amendment problems?
Well, I assume it probably has been. I assume if it hasn't worked its way up through the courts, I assume that the reason they have this is to go after crime, and they're using it as part of how they build their case. But I don't think it actually matters that much, because the court, neither the majority nor the dissent, thought there were any standing issues. So unlike some of the cases involving Holder v. NSA, or some of the cases involving kind of government electronic surveillance where you don't know whether the government's surveilling you or not, if you are out on the streets of Baltimore, you are being surveilled by this program, because it's capturing, I think there's 3 different surveillance planes that are up at a time. And between the 3 planes, drones, they're capturing 90% of the city at once. And so even if at any particular moment, somehow you're in the 10% that's not being photographed, just being out and about in Baltimore means you're being surveilled. So I don't think there are any standing issues for the plaintiffs. It might, in some cases, illustrate how exactly, in a criminal prosecution, how they sort of put all these techniques together to overcome Fourth Amendment protections. So I suppose that could be a more vivid illustration of the problem.
One thing that I noted, I can't remember if this is the dissent or the majority, but it was something like only 3 or 4 different identifications of pixels, whether that this is a person or not, is enough to figure out exactly where they are. And so it's not that much information you need once you know someone is one of these pixels, in order to figure out everywhere they went during the day.
Right. So I think that was, I'm not sure if we're talking about the same thing or not, but I think the plaintiffs had evidence that if you just could identify 4 randomly chosen points of data from someone's movements over the course of the day, and I think in the plaintiff study it was done using that cell phone location data, but the same thing could happen with this aerial surveillance program. They were able to identify individuals. They were able to identify 95% of individuals just with 4 points of location data. And you can imagine how that would be the case, right? Like, how many people start the day off at your house, go to your place of work, and then some other location that maybe is unique to you in some way, your favorite restaurant, or where you go to get lunch, or the grocery store that you shop at. It would be relatively easy, frankly, just based on knowing where someone started their day, to identify that person. And it might be that, yes, going into a house or going into a building, you're outside the view of the surveillance, and depending on the building, there might not be many people going in, or there might be a lot of people going in. So, someone going into a subway station or something like that, it would be obviously very difficult to track them coming out of the subway station until you know where the pixel goes. And if the pixel goes to their place of work, it's a limited number of people that would be going to that building. But some buildings, the only people going in and out of them are, like a small business or something. There's probably a limited number of people going in and out. And if you see one pixel go in from someone's place of business to their home every day for 45 days, you have a pretty good idea who that pixel is, even if you can't see, what color jacket they're wearing or something.
One thing that struck me about the court's analysis was that, this was a reasonable expectation of privacy case, not a property rights case like we've had in some recent Fourth Amendment cases.
Mm-hmm.
And it seems like the court took the most extreme reasonable expectation of privacy cases from the Supreme Court and just kind of wrapped them all together. Like there's this case that says, surveillance just above your house, aerial surveillance just above your house, that's actually for any normal person is going to be pretty intrusive, does not violate a reasonable expectation of privacy. And then wraps that with this statement in Carpenter that says that ordinary cameras on the street, that's going to be okay. And so when you put them, all these little bits that don't violate reasonable expectation of privacy tests, put them all together, well, that's not going to, the sum is not going to violate the reasonable expectation of privacy. Whereas Carpenter tells us that it's when you put them all together, that's when the real problem is, and just completely elides past that.
Yeah, it's interesting how the majority does kind of cobble together a whole bunch of different opinions, like cases that say, flying 1,000 feet over someone's backyard, or even a few hundred feet. I think one of them over someone's backyard is not enough to violate their privacy. Combine it with some of the other cases and say, well, see, this program's no worse than that. But when it comes to analyzing what the police are actually doing, it of course only views the aerial surveillance in isolation. And of course, flying over someone's backyard at 1,000 feet and taking photographs is very different than hovering over their backyard for 12 hours a day, every day, and taking photographs.
Right.
And,
only 12 hours a day. I mean, come on.
Right. The court makes a lot about the fact that it's only weather permitting and not at night, as though those make a big difference, and seems very credulous about the government's claims that yes, it is really following these restrictions, and even though the cameras have the capability of doing the photography at night, and even though the cameras have the capability of viewing people in much greater resolution that could identify them. Of course, they're not doing that. They're only looking at the one pixel. And given the number of abuses that we've seen using a wide variety of surveillance programs, I think it's a bit irresponsible for a court to be that credulous about it. I understand that they're bound by the evidence that's presented to them, but you don't have to have been paying that close of attention to know that these surveillance technologies get abused constantly, because there's almost no consequences for doing so. And at worst, a cop is going to get a slap on the wrist for it. And so even a lot of the limitations they claim they abide by, those probably go away if there's something that they consider important enough to waive those protections.
Well, a different kind of protection that Americans often are worried about is wage and hour laws and how those are fairly distributed across the economy. So far away from Baltimore, in the fields of Washington State, people work milking dairy cows, and their concerns were brought to the Washington State Supreme Court in an opinion that somehow was able to combine John Bingham and the birth of the 14th Amendment and the Washington State Legislature's requirement to enact these kinds of laws, plus the dairy industry. We have an interesting case, if not quite a coherent case, that Wesley is going to tell us about. So take it away.
So this case is Martinez Cuevas versus the DeRuther Brothers Dairy Incorporated from the Supreme Court of Washington. It was decided on November 5th. And it addresses whether the overtime protections, that is to say the requirement that you pay your workers for time over 40 hours per week spent on the job, whether those statutory protections have to apply to agricultural workers based on the Constitution. So the agricultural workers in Washington State, like many states, are specifically exempted from the overtime provisions of state law. And two dairy workers representing a class sued their employer, arguing that Washington's privileges or immunities clause, as well as its equal protection clause, made that statutory exemption unconstitutional. In other words, the Constitution requires the legislature to protect the overtime pay of agricultural workers, despite the legislature's express intent not to. And, there was a lot of telling evidence about the challenges faced by dairy workers in particular. These two plaintiffs, Martinez Cuevas and Aguilera, were working at a dairy farm that had 3,000 cows. It operated 24 hours a day, 7 days a week, all year round. And they were routinely made to work. I think it was 85% of the time they had to work overtime every week. They weren't compensated for the work that they did before their shift or after their shift, and seem really to have elicited the sympathy of the court in terms of how they were treated. I think it's a matter of public record that a lot of agricultural workers are treated poorly by their employers. And, as one of the concurrences points out, they're disproportionately migrant workers, either undocumented Latinos or people that are here legally who are overwhelmingly Latino in ethnicity. And so the trial court in this case held that there was a privilege or immunity that was covered here, but reserved for trial the question of whether or not the legislature had a reasonable grounds for exempting agricultural workers. And that struck me as a little strange. I mean, I don't understand how you're going to have a trial over the legislature's reasonable grounds for something, except perhaps if, we're going to trot out justifications about keeping prices for agricultural goods low and that benefiting the general public and the like. But the Washington Supreme Court granted discretionary review in this case, took it up and ruled in favor of the dairy workers by a vote of 5-4. And the majority relies on two constitutional provisions, the Privileges or Immunities Clause of Article 1, Section 12 of the Washington Constitution, and the Hazardous Employment Protection Provision of Article 2, Section 35 of the Washington Constitution. And what this does is it requires the legislature to pass laws necessary, it says, for the protection of workers in hazardous fields. And it names two, mining and I think it's construction. And then it says, and other similar occupations. And so the majority agrees with the trial court that there is a fundamental right to equal protection, equal statutory protection in the context of dangerous employment. So the idea is that because Article 2, Section 35 requires those protections, and because the legislature has granted them to other workers in dangerous fields, the legislature cannot, without a reasonable grounds, deny them to agricultural workers. Whereas the trial court wanted to have a trial about whether there was reasonable grounds, the majority goes on to hold that there really couldn't possibly be as a matter of law, given the nature of the work, given the purposes of the Privileges or Immunities Clause as it was originally enacted, that is to protect people from special privileges that were being given at the time of Washington's founding in 1889 to big businesses. As a brief aside, this was a populist period in American constitutionalism, and the Washington Constitution, along with those of many Western states, was really animated in part by concerns about evil banks and railroads and big corporations that were taking over state legislatures, allegedly. And this provision, among others, was designed to protect the little guy. And so the court looks at the history of the Privileges or Immunities Clause as it's been applied at the federal level, that is the 14th Amendment's Privileges or Immunities Clause, and in Washington state. And in doing so, I think really confuses the two provisions. It's something we see a lot in state constitutional law. There's kind of a free borrowing from federal jurisprudence without a real explanation for why things might be different. And the dissent in the case by Chief Justice Stevens and joined by three others really takes the majority to task for that, and points out sort of the different motivating the different motivations for Article 1, Section 12 versus the 14th Amendment. As longtime listeners undoubtedly know, the 14th Amendment's Privileges or Immunities Clause was, designed by the Reconstruction Congress to protect newly freed slaves and provide them with a broad base of rights against the states, but was quickly limited by the U.S. Supreme Court in the slaughterhouse cases to really only protecting a very small set of so-called federal rights. Well, the majority in this case says that may be, but our state constitution was designed to protect the fundamental rights of state citizenship. And one of those, as we see in Article 2, Section 35, is the right for equal protection in the provision of protections for workers in dangerous fields. I'm not sure who has the better argument here. I mean, one point that the dissent made that I thought was pretty compelling was that Article 2, Section 35 is not a personal right. It is in the section of our Constitution, Article 2, that addresses legislative obligations and how the legislature works. And if the legislature is required by the Constitution, as it is, to determine what protections are necessary for dangerous work, its determination that agriculture work doesn't require it should be conclusive, right? I'm not sure I agree with the dissent's idea that there's no way of enforcing that if you're an individual. But I do think it makes sense to say that this is really a restriction on the legislature, not a rights-granting provision, because if it was, it really belongs in Article 1 with the other familiar rights, like against unreasonable search and seizure that we were talking about in the last case. There's also I think, it's a practical matter, an interesting debate between the majority and a separate dissent by Justice Johnson about whether this case is resolving the application of its outcome prospectively only or also retrospectively. And what that means is, in practical terms, are these dairies and other agricultural businesses in Washington now required to pay back wages for overtime? Or does this rule only apply to future wages? And I mean, I don't think it takes much explanation to see that this could have profound impacts, particularly during the pandemic, on the viability of a lot of agricultural businesses around Washington. I mean, I suspect a lot of them would be bankrupted if they had to pay years' worth of minimum wage back pay. Again, I'm not sure who has the better argument there. The majority kind of dodges it by saying it's not at issue in this case. The dissent says, of course it is, and we should only be applying this prospectively. Agricultural businesses have relied on this for 60 years, and the previous understanding that they were exempt from overtime pay, and it would have great impacts on our food supply if we were to suddenly require them to go back on that. There's a separate concurrence as well from Justice Gonzalez that would have viewed the case through the lens of equal protection and recognized that Latino farm workers are a disfavored minority that are entitled to at least intermediate scrutiny under the Equal Protection Clause of our state constitution. and would have held, as the trial court declined to hold, that that the Equal Protection Clause is violated here. So, this all comes against a backdrop of decades of debate about the purpose and scope of Washington's Privileges or Immunities Clause. The Institute for Justice, in fact, has brought several cases trying to tease out what exactly that provision means in our state constitution. And every time it has met with real resistance from the state Supreme Court. They seem to view, by and large, our state constitutional provision. In the past, they've seemed to view it as being in lockstep with the federal provision, such that it's kind of like the Ninth Amendment. It's really an ink blot, a Rorschach test, not something that's actionable. There's always some excuse for why you can't use it. But here we see it come back to life in a 5-4 decision, where I think both the majority and the dissent have their doctrine and their history somewhat confused. And I don't say that casting aspersions. This is a complicated history and it asks really hard questions. I think one of the reasons that for more than 150 years now, lawyers and judges have been debating the purposes and the effect of the privileges or immunities provision of the 14th Amendment is because the stakes are so high. I mean, if it's true that there is a wellspring of rights, natural in character but undefined in the federal Constitution, well, then, it's a field day for lawyers from all kinds of persuasions to try to assert that their rights are important, their clients' rights are important, and that they're entitled to judicial protection. We've spent the life of our firm since the early 90s trying to provide some content to the concept of privileges or immunities. This seems to be the Washington Supreme Court's entry point for what it would view as the appropriate functioning of that clause, that it's designed to protect the little guy against industry favoritism by the legislature. And the legislature is required to have special reasons for favoring an industry over the little guy.
And one ironic thing about that, isn't it true, Wesley, that the one case IJ has brought and had an opinion on at the Washington Supreme Court was about trash hauling monopolies, if I remember right. And the court's answer was, well, trash hauling just isn't, it's just not among these privileges or immunities. So you can favor trash haulers and push the little guy out, and that's perfectly fine. But here, if you're not providing a protection of overtime, then that is pushing out the little guy. I mean, I understand the reasoning of this case if you have that backdrop, but it seems like a little bit of an odd distinction, especially when the court relies on all this history from the 14th Amendment, which of course was all about protecting, the right to earn a living.
Right. And they talk about the trash hauling case in this opinion, both the majority and the dissent. And they seem to both view it as the difference being that trash hauling is really a municipal function that government then contracts with businesses to do. And since it's a municipal function, they can do it on whatever terms they want, even if they're operating with private people that are actually doing the business. There's really no similar way of looking at this case, given the nature of agricultural employment. But again, I'm left with the feeling that we've got a lot of words about a lot of high-minded concepts, but there's not a lot of rigor in terms of how these concepts apply to specific instances. And really what we're getting here is what commands 5 votes at the Washington Supreme Court. If you can get to 5 because you're representing sympathetic agricultural workers, then you have a privileges or immunities right. But if you can't get to 5 because you're representing less sympathetic trash haulers, you can't. I hope that's not what's going on, but this is a 73-page opinion where the two sides are using largely the same sources to say that the other one is obviously wrong. And I think that this is an area of the law that is sorely in need of some academic and litigation emphasis so that we can get to a more grounded doctrine.
I thought it was interesting that the majority opinion, basically takes it for granted that the slaughterhouse cases were wrongly decided, and the dissent doesn't really push back that much on it. It sort of says, well, law journal articles aren't precedent and yada yada, but it doesn't really fight that point. Now, it doesn't need to, because the meaning of the federal privileges or immunities clause and the slaughterhouse cases are only kind of illustrative and incidental to Washington's privileges or immunities clause. But it's kind of another example of courts taking a look at the slaughterhouse cases and saying, yeah, this really was wrongly decided back in the day. Now, it's easy for them to do, and that has no real impact on how the case turns out, because they're, again, talking about the federal clause and not the state clause, and ultimately they're deciding this case under the state clause. But nonetheless, kind of an interesting maybe footnote to the journal articles out there that sort of say there's universal agreement that the slaughterhouse cases were wrongly decided. This is sort of example number 37.
Yeah, it's frustrating, right? I mean, everyone recognizes that slaughterhouse was wrong, but we're not even really beginning to get 150 years later. We're still not even really beginning to get the content of what it really ought to be. We all agree it's wrong, but there are probably as many opinions as there are legal scholars as to what would have been a right reading of the privileges or immunities clause. It's fascinating. I mean, I think for those of us that are really steeped in the law, it seems more normal that there's no understanding of what this means. But, for a layperson or someone that's not as familiar with constitutional history, this has got to be really befuddling. The fact that there's this sea change in our country after the Civil War, which is then echoed in many state constitutions, including Washington's in the late 18th century, and yet courts have no idea what to do with it. So, I mean,
on top of that, provisions like this one were influenced by the 14th Amendment, but they have their own genealogy as well, going back to pre-Civil War state constitutions like Indiana's and Ohio's, which have similar language from before the Civil War. So, the history's there. It's not that hard to put it together, and yet the courts, it's almost like privileges or immunities has just become such a boogeyman in interpretation that it's infected state courts, which have their own history of actually interpreting these clauses.
Yeah, well, one thing I wanted to see someone say here is that this provision's adopted in 1889. That is after the slaughterhouse cases. So if it were correct that, as we always assume, that the Constitutional Convention was aware of developments in federal law, they looked at the slaughterhouse cases and said, well, we don't like that. We want our own privileges or immunities provision that does protect the fundamental rights of state citizenship. Now, that only gets us so far. The question then becomes, what are the fundamental rights? So now you have a fundamental right to overtime pay in certain dangerous occupations. I don't know which ones are going to be included. I'm pretty sure lawyering's not going to be, but perhaps a bus driver is a dangerous job. Perhaps it's not. Perhaps police are constitutionally entitled to overtime pay now in the state. Perhaps not. I don't know how this plays out in the end. I do know that if the legislature attempts to repeal this legislatively, that law is probably going to get struck down. We've now constitutionalized the provision of overtime pay for agricultural workers. As a policy matter, that kind of sounds like a good thing to me. As a legal matter, it seems quite strange.
Well, although it is in the Constitution, right, that the legislature shall do these things, which you can criticize the court for interpreting that, but then also perhaps the criticism is of whoever, the people who wrote the Constitution in 1889 and putting these, maybe it's a right, maybe it's a duty of the legislature, but it's in there that the legislature has to act in this way, which shows some of the follies of putting positive rights in constitutions. We see the same thing, of course, with educational funding clauses that many of you listeners may know about, where there's a right to an education or there's a right to public funding of education, and then the legislature doesn't do a good job of that. And then you have litigation about, well, how much should it be? Of course, we at IJ sometimes argue, well, you could do that through school choice programs. You don't have to have the state run it all. But all that is in the mix in litigation. Interpreting a constitution that's pretty straightforward, that legislature is supposed to do that. It's not as easy, though, as, say, striking down a ban on flag burning. That's a pretty straightforward thing for courts to do. But when it comes to this kind of policy matter, then judicial engagement shows some limits, because perhaps judicial engagement isn't as easy when it comes to legislating.
Perhaps not. I mean, I think that you're right. It's important to remember that a lot of these constitutions are written, of course, with the input of lawyers, but the members of the convention aren't necessarily lawyers. I mean, I know that our convention was largely farmers and, civic leaders that had nothing to do with law. And you're right that they put it in there that they wanted people to be protected in dangerous occupations. We can debate whether what they meant was the mines that they mentioned or agricultural workers or the like. It's certainly possible that agricultural work has become more dangerous over time. So now we're talking about living constitutionalism or originalism. And I don't know. I mean, I think that if I was a professor at the University of Washington, I would be wanting to teach a seminar about this case.
I think we'd be remiss if we didn't also mention, while we're talking about what the scope of the Privileges or Immunities Clause is, that we have a cert petition pending currently before the U.S. Supreme Court about the scope of the federal Privileges or Immunities Clause. And that relates to the slaughterhouse cases discussed in this opinion, which essentially gutted the Privileges or Immunities Clause, except for a handful of things, one of which is the right to use the navigable waters of the United States. And so IJ right now has a cert petition for the Supreme Court about whether someone trying to operate a ferry on Lake Chelan can be protected by the Privileges or Immunities Clause, the federal Privileges or Immunities Clause, against a state-created monopoly. So these issues continue to be litigated both in state Supreme Courts, the federal Supreme Court, and IJ's at the forefront of raising these issues.
Yeah, and that comes out of Washington, right? So it's like, our state's like ground zero for privileges or immunities litigation these days.
And that's a case that takes Slaughterhouse at its word and says,
right.
You give us, in that opinion, a few rights that are of U.S. citizenship, including navigating the navigable waters. And so take us at its word. And so we'll see if the U.S. Supreme Court addresses that case. We'll put a link to it up on our webpage. You can also find it. It's called Courtney. It's been litigated for many, many years by a few folks at the Institute for Justice, including Dan. And we would like to not including Dan.
No, not me. Michael Bendis is the.
It's just very. I know, but Michael Bendis, of course, is the captain of the ship of our effort in that case. But there are others as well. Well, I wanted to thank Dan and Wesley for weighing in today on our pandemic TV viewing edition. I hope you find your own series to watch these coming weeks as we get into the holidays. And for everyone, I'd want to also ask you to get engaged.